webinar. I am Chris Irons, Strata consultant, former Commissioner of Body Corporate Community Management. With me, as always, Frank Higginson, partner Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone. Again, on this cold Thursday, lockdown Thursday.
Cold lockdown. Temperature is a topical issue. We're talking about temperature today. Here's a fun fact for everybody. When I woke up this morning, the virtual temperature was 0.1. There you go. Who would have thought? And yet we're going to talk about air conditioning today. Go figure. Some of you watching might notice that we don't have the scroll going across the screen anymore. I'm going to put up for you, everybody, if you happen to be watching this, if you're watching this live, as always, chuck us questions in the comments. Very happy to try and get to as many of those as we can live. But if you're watching this after the event and you've got a particular question that you want to pose to it, click on the link that we're just putting up now. Any second, there it is. And that's how you can get a question to us, which might be a bit more specific. But as I say, as always, ask us questions live. Today, though, as I say, air conditioning. And look, Queensland, and I know people from interstate sometimes watch these as well, but in Queensland, it's a bit of a no-brainer to have AC, I reckon. You got to, although you don't, do you, Frank?
No, the joys of old houses and just ducting, all that sort of stuff is a very expensive exercise, and I can't quite pull the trigger on it.
Okay, fair call. So the same applies for Strata, of course. And in most situations, it's pretty smooth. Go through the motions, it gets installed, everyone's happy. But we've seen plenty of instances, haven't we, Frank, where it hasn't gone according to plan. And it can be very stressful and very tense.
Absolutely. And usually, dead set most times, it's because there's a niggle about something else. As we always find in Strata, the air conditioning itself isn't the problem usually. It's something else that has created some personality issues, and then the fight happens to be over the air conditioning. So, and particularly, well, I suppose we'll get into the type of lot you're in and all that sort of stuff. It does come up a lot. The same as, what we're trying to do with these things is deal with some of the common issues that we have come across our desks every other day. And I mean, literally, I got one of these disputes yesterday.
Yep.
And it shouldn't be a fight, but it's going to be a fight.
And look, the issue isn't so much about the concept about installing air conditioner. That's never the issue. The issue is typically about where things get installed. So, and particularly the condenser, and where a condenser is being placed on common property and how it looks. We'll get to all of that in a minute. Let's start at the start then, Frank. So if a lot owner is installing an AC totally within their lot boundaries, with nothing affixed to the exterior or nothing impinging upon common property, happy days.
Absolutely.
That's right,
plug it in, yep. Press play, done. It's no different at that stage to a television.
Yep.
All good. Kettle.
Yep.
100%. Zero.
Although to be clear to everyone watching this, if after installation then the AC turns out to be noisy or it's causing a disturbance to neighbours, then that is an issue at that point. You'd hope that you get that figured out before installation though, and you would have gone through the different options available to you. Just on that issue of noise, in our prep for this one, we do prep, everyone, funnily enough, found out that Brisbane City Council, and I imagine other councils across the state as well, have provision for noise emanating from an air conditioning unit. And that might actually be something for you to pursue if that's a problem. So we're just going to put a link for that Brisbane City Council air conditioning noise issue up on screen.
And so that's going to be council. You complain to council on that one, and council will then go and do whatever it has to do under its local laws. Yeah? As opposed to go to the body. Yeah, okay, cool. So there's another source of
that's my understanding. And I guess we make this point frequently in webinars. Not everything that happens in a body corporate is a body corporate responsibility to resolve. This might be one of those cases, but okay. Let's assume though that we've gone through all of that. So let's cover off on the main issues then, Frank. So responsibility. Let's talk building plans for a moment. So building format plan, that's your typical high rise.
Yep.
The owner is responsible for an AC system, including the associated pipes and wiring, if it's supplying the service solely to the lot, and even if the system is on common property. That makes sense?
Yep. It does. And I suppose probably for me, little point here is high rises are always going to be. So I suppose back to Plan 101. So a building format plan, you own sort of from halfway in the walls inside. So if you're up on the 30th floor, effectively what you own as a piece of real estate is a piece of airspace that happens to be surrounded by the building itself. If you're in a standard format plan, which is also known as a group title plan, you actually own a block of land upon which a lot is constructed. So I think it's pretty safe to say that if you're in a high rise, you are going to be a building format plan. If you're in a low rise townhouse estate, you are probably standard format plan, but it's quite possible that the plans might be registered as building format, even though they're on the ground. So you can't assume that if you're in a villa, that what's surrounding your property is yours to do with as you see fit. So really
it's likely, but
it's not necessarily. So it's just important to be careful on that. It's a quick and easy way to tell. It's the plan type under which you bought. Bottom right-hand corner, it has plan format. It'll say building or standard.
Yep. Okay.
Anyway, be clear on that.
So in standard format, it's not usually an infrastructure issue, but it's a vital issue nonetheless because the pipes are in the owner's lot. But then it comes down to look and noise, which we're going to get to in a minute. And it follows that it's the owner is responsible for any issues arising out of anything that we just spoke about then. So let's talk about approvals, because this is where things go off the rails when it comes to AC installation. So this is us assuming that installation is going to be on common property. And by that, typically, Frank, we're talking about the condenser, aren't we?
Yep, and maybe some pipes through the walls and some drip things over the side, or maybe it's even up on the roof. Like some condensers put on a whole bunch of roofs and then come down, but absolutely.
That's very common. So the committee can approve that if it's installed on common property, provided that the following conditions are met. So it's a minor improvement, so it's got to be under $3,000 installed value.
And I reckon that includes GST.
Yep, I think so.
So 27 plus GST is the number. Yep.
Indeed. And the improvement does not detract from the appearance of any lot or common property in the scheme. So that's where bylaws kick in. And then a third one, the body corporate has to be satisfied that the use of enjoyment is not likely to breach an owner's duties as an occupier. Important to note, Frank, those three are and provisions, not or provisions. That's very different, isn't it?
It is. So it's not a choice. You've got to tick the box on every single one of them, or three of them, to be able to approve, or have the committee approve air conditioning.
If one of those things isn't met, then it goes to a general meeting and would be approved by ordinary resolution, typically.
Absolutely. And I think probably you look at them, like the first one's a factual thing. It's a dollar value. It's worth X dollars. Pretty simple. You got your invoice, you know what it is. The other two are certainly more subjective. So what is detracting, excuse me, what is detracting from the appearance of a lot? What is something that might interfere unreasonably or promote a breach of the owner's duties as an occupier? So they're very subjective things. And it's pretty rare, actually, when you sit here and look at the specific wording. Most things in strata land, you can't say no because something might happen. So if we come back to pets all the time. You can't refuse a pet because the dog might bark. You give it approval on the condition that it doesn't bark unnecessarily or unreasonably, and then if the condition's not met, there's a bylaw breach process and away you go. But it's not sort of shoot first and ask questions later. This one, in a sense, turns that around because the committee can actually, in a sense, say no if they think something's going to go wrong in relation to unreasonable interference, which is pretty unique.
It sure is. And so it's a process of elimination, isn't it, Frank? First level is the money. I think in most cases it would be above 3,000. You would think, depending upon what you're installing. Maybe not. Maybe if it's a small lot, it will still be under 3,000. I would suspect. But in a lot of cases, I reckon you'd exceed $3,000. So, but anyway, you go through those steps, then you get to the last one. And what effectively the legislation is talking about there is the nuisance provisions under Section 167 of the Act. Now, it's interesting, Frank, that the topic of nuisance comes up. We were at a meeting for the reform process, the body corporate legislative reform process today. And while we're not at liberty to talk about specific things that were talked about there, the issue of the nuisance provisions did come up. It's a tricky one, isn't it, Frank?
It is a very tricky one. And again, this is one of the difficulties with the legislation. You know, it's sort of, we said this when the new regulation modules appeared in March. It's getting more and more complex just in terms of understanding the various nooks and crannies you can fall down. But when you talk about nuisance and unreasonable interference, they're very subjective tests. You know, what might be a nuisance to me might not be a nuisance to you. I might have particular sensitivities. Maybe I don't like something that's going on because of something in my history or whatever. And it's a really, really difficult thing for the legislators to be able to be as specific as they could be. Like a figure, let's talk about air conditioning noise for a second. So is there a decibel rating for air conditioning noise above which something becomes a nuisance or it's not? Or is it deadened by trees and carpet and surrounds? And if we're going to go and define that type of nuisance, what other type of nuisances could we be defining, and by reference to what?
Exactly.
So this is the so that the Strata title working group thing. One of the things that, I suppose, completely off air conditioning for a minute, I suppose you've been through it quite a bit in your time in government. It's my first real time doing this, and I'm really enjoying the process of understanding how the government gets to its position on certain things, because it's impossible to really, as much as the conversation came up, it's not impossible. It's really, really difficult to be more prescriptive about nuisance. And there's a degree of, you can't cater for every eventuality. So you have to leave that to the subjective or objective interpretation of adjudicators. Because it's going to depend, as we talk about a little bit later with one of the case studies, different facts are in every single different building.
I suppose this is where the concept, we talked before about bush lawyers, this is where the idea of a bush engineer comes into play, I reckon. It's all well and good to, if you're on the committee, to say, I'm concerned about the noise or I'm concerned about the appearance of that air conditioner on common property. But unless you've got some kind of expertise about that, it's veering into unreasonable to be voicing those kinds of concerns. You need a basis on which to say that. So if you say, I think that air conditioner is going to be too noisy, so therefore I don't approve it, that's very different to saying, I believe that air conditioner is going to be noisy because, in my experience, that particular model tends to do this. And that's the effect. And here is some information from the manufacturer's website which tends to demonstrate that. That's a much safer approach than simply saying, I don't like it. With apologies to Pauline Hanson. But the owner's got obligations too, Frank, and probably the big obligation there is you don't ask for approval the day before the tradies are due to show up and do the work. Yeah.
No, it's interesting because this is, I mean, I suppose in terms of our practice for acting for bodies, corporates and lot owners with these particular issues, and that's what we do. So I think, you know, and that this has changed the land. One of the module changes, again, that owner's motion, where owners can actually now require committees to make decisions, has changed the landscape around these things. So I think from, you know, as Chris was saying, from a committee perspective, it's about being reasonable as having objective evidence to support whatever your particular opinion might be. It's about engaging, ideally, with owners if you've got specific concerns. I mean, in theory, you could say, you haven't given us enough information, but what more information could you be asking for? And from an owner's perspective, if you are making an application to your committee for something like this, it's a matter of making sure that you cover off those 3 dot points. So it is less than $3,000. It's not, you know, it's not going to detract from the appearance of a lot. And this is why, this is what I'm doing with respect to that. Maybe it's a cover. Maybe there's some planters around it. I don't know. And the third one, it's not going to breach my duties as an occupier, because A, it's quiet. It's the best rating one on the system here in the machine. Here's the choice recommendations that talk about the quietest air conditions, and there's number 1. It's that sort of stuff. It's not just, here's my, tradies are arriving tomorrow, I want to put this in. Or even worse, the tradies do the job and the committee says, mate, is that on common property? think you're going to ask us about it. And I think that's probably, again, what we'll talk about a little bit later on today in terms
And
of these case studies.
and that can be ordered to be removed. It has happened that an adjudicator can order that something not properly installed on common property be removed, and that is a substantial job if that happens. So you want to avoid that for all sorts of reasons. We often talk about reasonableness and acting reasonably. One of the other aspects of acting reasonably is to take in the specific circumstances too. So if you're on the committee and there's a request before you to install, is it reasonable for you to make them wait? Is it reasonable, for example, to say to someone, oh, that needs to go to a general meeting, the next one won't be for 6 months. In the meantime, that 6 months takes us through summer. Is that a reasonable? And forget about reasonable. Would you want to be in that position if it was you? I think the answer is always going to be no there. Also, maybe the owner in question needs air conditioning because of a medical condition. That can happen as well. So you've got to take those points into account. And then we talk about the second aspect of those 3 points was the bylaw. Of course, as we've said many times, just because there's a bylaw in place doesn't mean it's reasonable or valid, does it, Frank?
No. And again, the Titles Office will register them as long as they're signed right and the exclusive use plans are right and the fees are paid. So you could have, and certainly our collective belief, and we tested this the other day in a presentation without checking with each other beforehand, is that probably a less prescriptive bylaw is a better option. So, and you might even come back to saying the bylaw should really be before you install anything on common property, you need to seek the approval of the committee. And that then leaves the committee open to imposing reasonable conditions around whatever that might be. So rather than having a bylaw that says you can install a condenser provided that it has, I don't know if air conditioners get rated by decibels, a decibel rating of less than whatever it might be, because that arbitrary number is not necessarily going to be right for every position that a condenser could be installed in that building.
Yep.
If it's on the roof, why does it matter? If it's sitting, I suppose, between balconies and the balconies are open, then maybe it does. So it's that horses for courses thing. So what not having a very prescriptive bylaw will allow is the committee more flexibility around the conditions it imposes. But if you've caught in a position where it is a prescriptive bylaw and it's not necessarily going to be reasonable, then that's a bad position for everyone.
I think so. Just putting up a link now. We talked about timeframes and we talked about an owner's right to put motions to a committee. So we're just putting up the extract from the legislation that covers off on that, just for your information. Let's go over some common questions that arise, Frank, about this. And these are things that we've heard numerous times at webinars, seminars, everywhere. So one of the first common questions. A lot of other owners have air conditioning, but the committee is saying no to mine, and that doesn't seem fair. So I guess the response there is that committees have an obligation to act reasonably. And it means taking each case on its merits. So there's two ways of looking at that, isn't there, Frank? On the one hand, just because everyone else has one does not automatically mean you're entitled to one. There may be a particular aspect of your installation that's very different from everybody else, which might make it completely reasonable to say no. But of course, the flip side of that is from the committee's perspective, if this request is the same as 6 others and they've been approved, and you're saying no because you don't like that person because they spoke sharply to you at the last AGM, that's not going to cut it, is it?
No, and the question is why. You know what I mean? So from the owner's perspective, it's why. What's different this time? And I think it's very dangerous for inconsistency in decision making around approvals for committees. But I think that's the question. So it is possible that other people have something that you might have not, and it's also possible that that might be a reasonable or an unreasonable decision. I mean, that's very grey and nebulous, and unfortunately, back to what would define a nuisance before, acting reasonably can be a very subjective thing.
Definitely. The next common question that we get is there are some unapproved air conditioning installations at our building. What are the ramifications? Well, it can actually be pretty significant depending upon the circumstances. Unapproved improvements to common property can mean in some cases an insurer will decline to insure. That's pretty serious. And importantly, adjudicators have been very clear on this, that just because something has or has not been done in the past, that's no reason to either keep or stopping from keeping doing that. Did I say that right? Yeah,
I think
I think
so.
I did.
Yeah.
Yeah.
Yep.
So in other words, if the committee is aware that there are half a dozen unapproved ACs installed on common property, it really should be doing something about those. It should not let them go unattended to.
No, it should be regularising the approvals. So in theory, what you've got is a breach of bylaws, you would think, which people have approved, have installed things on common property without committee consent. So the correct way to deal with that is to go through the process of actually giving the consent and keeping that in the body corporate records. And it's interesting, the insurance thing, the insurance market is getting hard. I mean, and for those viewers in North Queensland, absolutely would know that already, but it's also getting harder in other places. And what insurers, anecdotally, we're both getting don't like is absolutely things that have been built. And another big one down here particularly is enclosing balconies, because from a fire safety perspective, that can be really dangerous. So when you come back to you know what I mean? I did 6 months of insurance law at uni, probably in the early 90s. The duty of utmost good faith. We all have that with respect to our insurers and our insurer to us, where you've actually got an obligation to disclose to your insurer basically almost anything that might be material in relation to their decision to insure you. So from a body corporate perspective, it's very easy to tick a box on an insurance renewal form and not consider the things that you might or should be disclosing that might be material to the insurer's decision to actually insure you. Because if you don't disclose things and those things actually cause the damage that you might be trying to claim on, it's open to the insurer to disclaim liability. Yep. It's just a bad place to be.
Yep, definitely. A couple of questions there, which we will get to before we conclude today, but we'll just keep going with a couple of other points. The final common question that we want to cover off today, there's a bylaw about AC installation that is nearly impossible to comply with. What can I do about it? Key bit is nearly impossible. Nearly impossible does not mean impossible. So it's quite appropriate for the body corporate or the committee to put conditions upon installation. That's fine, reasonable in a lot of cases. Depends how unreasonable those conditions are. So I'm certainly familiar with circumstances where somebody's asked to install an AC and they were given certain conditions which they then met, and then further conditions were asked and they were begrudgingly met the second time. Then another round of conditions were put after that. It's how intense, how unreasonable, how severe those conditions are, which is the problem. If the committee
again,
knows,
we're back to section 180, aren't we? Bylaws cannot be oppressive or unreasonable.
Yep. And if you're on the committee and you know that your bylaw around that kind of thing is unreasonable, then it's a good idea to get your bylaws reviewed. There's no point continuing on with bylaws that you know are unreasonable under the circumstances. I want to cover off in the very short amount of time that we've got left, Frank, the mysterious world of statutory easements.
Yep. So Chris will put up a link to a case now, and I suppose this start with, as with all of these things, everyone's individual circumstances are different. So, and interesting enough, we're going off the BCCM grid and we're going to what's the Land Title Act, and that Land Title Act provides that an easement. So this is really a statutory easement. So an easement normally would be, easiest example is a battle axe block. You've got a house at the back of a block, there's a house in front of yours, and the driveway to the house at the back is probably going to be, if the land is owned by the house at the front, there'll be an easement over that driveway benefiting the land at the back. And that's not a statutory easement, that's a contractual easement. So there's a written document registered against the title of both properties that will say the person at the back can come and go as they please, the person at the front can't lock the gates. It'll set out who's insuring things, who's bearing the costs of maintaining the driveway and all that sort of stuff. So that's a separate contract in effect. What the Land Title Act creates is a statutory easement, which exists by virtue of the legislation itself. And that says that an easement exists in favour of a lot and other lots and common property for supplying utility services to the lot and other infrastructure reasonably necessary for that. And those rights can't interfere unreasonably with the use and enjoyment of other people's lots. So again, to a degree, fairly consistent with what the BCCM Act provisions would otherwise provide. But the thing is, it creates that easement as of right or as of law without anything further. So you don't need a written contract. It's created there in the legislation itself. So we're back to what utility infrastructure, air conditioning pipes and those sort of things definitely are. Is it interfering unreasonably? That's back to the same sort of test we were talking about before. And the link to the case that Chris has put up is a commercial building or a commercial scheme, big ticket industrial estate. So that's, in a nutshell, what happened was one of the tenants wanted to put air conditioning in. Because it was a building format plan, they had to go through common property to do it. They made an application to the committee. Committee really didn't say yes. Tenant occupier went ahead and did it anyway. And then there was a massive blue about was a bylaw breached in relation to approval, and so on. So if you actually want to read the decision, it's quite interesting because you'll see that the tenant made a really serious explanation about why they needed air conditioning. So back to what Chris was talking about before, in the middle of summer, might be health reasons. In this one, more than anything else, it's work health and safety for the employees of the business.
Yep.
So you can't work in a big shed and get scorched every day. So we can't wait. Here's all of the material. Here's all of the conditions on which we're willing to do it. And effectively, what ended up happening, is from an adjudication perspective, is that the committee's attempt to enforce the bylaw was sort of washed away in a sense, because what the adjudicator found was the committee was acting unreasonably in not ticking the box on that approval, because the application made by the tenant was effectively almost perfect with the way I read it. They really went into the detail. Now, again, that does talk about statutory easements, so that's why that came up, but it's also illustrative, I suppose, of how adjudicators look at committees that mightn't be doing what they should be doing. What I say sometimes, it's sort of the illusion of choice. It might be that you think you've got the ability to say no, but in this one, they didn't. And again, in a commercial scheme with staff, air conditioning is obviously going to be a very important thing. If we're talking about residential units, which a whole lot of people, probably most watchers of this, are going to be residential unit related, not necessarily as important in relation to the work health and safety thing, but that's not necessary to say that you can't make other grounds on which the committee might be acting unreasonably. So have a look at that. Sections there. It's very short and sharp, but that's what it can be used for.
Indeed. Got a couple of questions there before we finish up, Julia. I know you're a regular watcher. Thanks again for tuning in. What happens if an insurer declines to insure? You're in trouble.
Well, Chris, here we go. Alternative insurance.
Yeah.
Yep. So body corporate's got a statutory obligation to insure, and if it can't get insurance for what it's required to do at law, well, I suppose somebody's corporates just ignore it and let it go, and they're in black and white breach of legislation. That's catastrophic for everyone, including the committee. What normally happens is that you can get insurance on some terms or with some exclusions that aren't consistent then with what your statutory obligation is, and your only choice is to make an application then to the commissioner herself, previously was himself with Chris, for, I suppose, what do you call a sanction to not comply with the legislation in relation to that particular component of the insurance, probably for a 12-month period. So Chris wrote the first couple of those in his last role as commissioner, and we've been successful in a couple of those with clients in recent times, where they can't quite get what they should be getting and have tried really hard to get it. So if you need help on that, just shout.
And also, probably the first step is that you need to keep asking, either through your broker or directly with insurers. You just need to keep asking and make sure you've exhausted all the options. Glenno, I know, again, regular, thank you for tuning in. 2 questions. Any thought on a general meeting motion approving AC installation within exclusive use areas in villas under a building format plan? Not sure if you're talking there about what wording to use or what process to use. What do you think, Frank?
Well, I suppose we'd come back to where we started. General meeting motion's only going to be required if you don't hit one of those 3 categories: the spending limit, the appearance and the breaching of duties. Other than that, then it's a matter of putting it up as a proper motion, like you would any other motion. Body corporate approve installation of X. You don't need to probably deal with cost then on whatever terms and conditions you actually want to do.
Yep. Give detail. Here's what it is. Here's what it'll look like.
And I suppose that might be an example, mate, too, of we're talking about a villa, which is probably, to me, connotes it being on ground level, but being a building format plan. So that's exactly that group title standard format plan issue we were mentioning at the start.
And second part of that question, any plans for a webinar on solar panels? Well, why not? We can add that to the list.
Yep.
Thank you for the suggestion. Yeah, appreciate that. We have come to the end today. So I think the bottom line out of today's webinar is that it should be relatively smooth sailing to get AC installed, but there are some things you need to keep in mind, both from a committee perspective and an owner perspective, and just have a really good think about those three things that all must be satisfied to install on common property. Next week, gold-plated committees.
Well, how topical is that post the Olympic announcement yesterday?
Indeed, yep. Gold-plated Brisbane, now it's gold-plated committees. How do you get a confident and skilled committee at your scheme? We're going to cover that next week. But in the meantime, don't forget to register for our newsletter, because we'll be announcing the August topics, gosh, probably next week sometime at this rate. And again, as always, that link at the start, if you've got a specific query for us, put your details into that link right at the top there, and someone from Hines will get back to you. But in the meantime, Frank, thank you, as always. Thanks everybody for tuning in. We appreciate it.
Bye.
We'll see you next week.